Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com.
Hi everyone, welcome to episode 47 of the Immigration Lawyers Podcast. This is another recap, a weekly recap from June 26th to July 2nd. Coming in one day late because of the 4th of July holiday. Things have been a little crazy. Frankly, casework has been nuts, especially with the executive order. So I'm just going to jump right into it. It has been a fantastically bad week for immigration. If you're an immigrant, that is. First of all, the House signed two bills holding back immigration, creating more restrictions. And it isn't necessarily holding back, but one bill is about sanctuary cities. This catch-all term that they've created, the government said they're going to withdraw funds from police forces that are not going to detain immigrants if asked by federal government for them to be detained until federal authorities come in. Now, this is an interesting law because, in my belief, it violates parts of the Constitution by federalizing local police officers to do immigration work. Some jurisdictions are into it and they're accepting it, some aren't, and they're going to have some consequences. So we're going to see how that all works out. The second law is called Cates Law. It was a backlash against a case where an immigrant that was, re-entered unlawfully was detained, let go by the police for crimes, alleged crimes and such. Eventually killed a person, and it increases criminal repercussions for people that have been deported and re-entered. There's some issues with the due process in that where people aren't allowed to get proper hearings for if they've been found removed, even though they shouldn't have been and stuff. But overall, it makes things more hard. Also, DACA is going to see a severe hit because about 10 attorney generals of 10 different states are planning on suing the federal government so they can begin to phase out the deferred action for childhood arrivals programs. This is one of the stars of the immigration system that happened under President Obama, and so far Trump has kept it going and people are getting deferred action. But essentially they're saying this should be phased out. So we'll see what happens with that. Along with that, ICE has gone much more aggressive. They've been coming to people's houses, going to talk to neighbors. There's a case in Georgia where they blocked a neighbor from being able to leave their house until they answered questions. So there are some due process issues and criminal procedures, what is it called? Crim Pro, stuff that going on there that could be an issue. Also, they're targeting families and relatives of those UAC, those unaccompanied children that come to the U.S. for smuggling if they participate in the child coming to the U.S. in some way. So that's something that's they have to be very careful of. And another thing that's been happening along the news is sports teams of foreign countries being denied come to the U.S. This time last week, an Afghan girls robot team was denied for an international competition from getting a visa to enter the United States. So it's getting more and more, almost every month or every week, hearing about these high-profile cases where visas are being denied. Now, obviously the biggest news and everything is the reemergence of the travel ban, the Supreme Court's decision to let some of it happen for the next couple of months. The biggest deal that happened with this issue was the K-1. Originally, the State Department's interpretation withheld the K-1, the ability to obtain a K-1 if you're a national from one of these countries. But after about 12 hours to 16 hours of, pushback happened, they made it so K-1 fiancé visas were okay. Before that happened, I was contacted by Associated Press to explain what the situation was, do an interview. They were about to write an article. But they had to pull back because the facts on the ground changed. So that was interesting that they were saying, the report I was talking to, that immigration is going to be a bigger and bigger part of the news cycle just for them as well because of the nature of events that are happening. Now the travel ban has some parts of it that are still unclear. So they specifically say an EB-1C extraordinary ability self-petition is not permitted because there's no connection with the U.S. entity. However, there's no mention of the EB-2C national interest waiver and how that goes, because that could be a self-petition, but on the other end, it's also a national interest waiver. So in essence, it might be a waiver on its own. It's so new. I haven't heard about cases coming out and people being able to get the visa in this way. That's something very interesting to look at. The harshest is going to be of this travel ban is going to be against diversity visa lottery winners, because a lot of them don't have ties to the U.S. and by waiting the 90 days, the number of diversity visas might run out sooner or later. Also, those countries that are part of the ban a lot of times have administrative processing, which means even if they do get the interview before September somehow, they may not be able to get visa in time due to administrative processing reasons. Now, in general, the executive order does have language in it that permits waivers and stuff like that, just in general for all types of cases. But we'll have to see how that actually plays out in real life when they're doing it, how easy it is, what the process is going to be, and all that. Another bigger news for practitioners is the update to Form I-485 application for adjusted status. So they took a 6-page form, which was the best form that existed because it was so short and easy. They made it into 18 pages, I believe, and they increased the number of immigration and security related questions. So now they specifically ask, have you ever worked in the U.S.? They specifically ask about the 3 and 10 year bar questions. When they ask about your parents' names, they specifically ask for their current names and then a maiden name, for example, if a mother changed her name. So they're much more specific, much more room for problems to happen. Their goal was to make it easier for people to do. So one of the hardest parts I've seen people have when they're doing their own is filling out the boxes of, in a marriage case, which box you're supposed to fill out. Is it the first box, the second, whatever? Now it's much more clear that if you're doing a family petition, which box you're supposed to mark. However, the additional security-related questions are going to cause problems for people if they're trying to answer those. That's something that's going to confuse the world out of them. So we'll see how that goes. Now, one thing I talk about a lot on these podcasts is reasons why clients need immigration attorneys. So I had 2 examples happen this week. One person called me, did a K-1 on their own. They said, it was approved 2 months ago, but they still haven't got an interview. So I told them, well, sir, you need to schedule your interview yourself. K-1s aren't like immigrant visas where you get a letter from the embassy saying your appointment date. You got to go in the system and do it yourself. So the guy just wasted 2 months away from his fiance. If he was going to waste 2 months, I would have just said, do an immigrant visa, have her come with the green card from the beginning. The goal was to save 2 or 3 months by doing the K-1. But he saved money by doing it, but was the money worth the 2 months he didn't get to spend with his fiance? So what is the cost of time? Is it worth the attorney? He did the K-1 that I want to F himself. It seems like he did it successfully, but there's these kind of issues that come up where an attorney can help you. Another case was a person who was married out of state. According to that state, once you get married, you have to go online and order this marriage certificate to come in. Well, they came to me after I've done the application and spending a lot of time on it, and they really wanted to work it fast because they wanted to get a work permit real quick. And I said, where's the marriage certificate? They showed me the piece of paper they got when they were married. I said, well, this doesn't count. Do you have the original one, like the main one? Maybe we could submit this, but you want the main one. And they're like, we don't know, isn't this the main one? So I looked it up. They have to actually order it. It's going to take like a week or 2. So it just delayed the case even more. Sometimes in California, I'll mail it with that certificate that they give you at the beginning. But the state they were in, the certificate looked like a cartoon, like drawing kind of thing. I wasn't really comfortable in sending that in. It looked very illegitimate. So again, could they have done it on their own? Maybe, maybe not. Let's say they did. They caused unnecessary delays because they tried to do it on their own. And so there's a value to that. Time is valuable. And that's part of what I try to tell people that are trying to hire an attorney and making their decision. It's not easy for them to understand that until it happens, but those are the kind of situations we have to deal with. On a really annoying side that I know all of you have been dealing with is EAD delays. Employment authorization documents are taking much longer than the 75 days USCIS says they'll do it, much closer to a 120 to 140 days. Expedite requests are falling apart. I used to be able to do a quick expedite request when I faxed USCIS the evidence of why I needed it. Now expedites are just lagging like any other just regular case. And I've been in contact with a few different attorneys who've done expedite requests, and I've reached the same problem I have, which is USCIS is just not moving on them. EADs, advanced parole, AP, I don't understand why these things need to take any longer than they need to. So they definitely, I need to study the system of what requires them to be looking at these for this long. It seems like once they do the biometrics, there should be some electronic situation where they just issue these cards, but that's something I have to look into. But it's a serious problem because people are here stranded without a social security number for months on end until they get it. And frankly, for most of my cases right now, I'm getting the green card before I'm getting the work permit or advanced parole. So that just doesn't make sense. Why would they even have an application process if it's going to take longer to get the green card. The whole point of that EAD AP combo is to hold people over until lawful permanent residency is reached. Now, if you go to the USCIS.gov website and you do and you look at case timelines, how much their estimates of cases are, it'll list, it says that the case is pending for more than 75 days, you can make an inquiry. So I recommend everyone keep track. Once the 76th day hit, call USCIS and let them know that there's a delay in the paperwork. So at least they're on it, that we're following up with them and pushing back for these significant delays that are happening. And delays, my clients keep calling me. That's more time and attention requires from me. I have to write letters and stuff. All that is extra legal hours I have to put in. And with the flat rate structure, it's not expected. Maybe I should include a part that says if there are delays to your EAD, or if you want to expedite EAD, there's extra costs. I may do that in the future. It was a courteous thing I do before because it would rarely happen, but now it's so consistent, it's just part of it, that I have to expect it to happen, and it figures into the fee structure. Just like when I'm doing consular processing now, there's an automatic increase in fees because more likely than not, I'm going to have to wrestle with the embassy and the embassy over some random issue. One point I like to talk about a lot is keeping up on education. I had a client call me. Luckily, he doubted his attorney and wanted to follow with me about it. Person came here, got DACA, then got TPS, and was able to stay here on that. Then he got married to U.S. citizen. So his lawyer said, do the advanced parole, re-enter, and then you could adjust status. And I said, listen, don't do that. You have TPS. The new court case in Ninth Circuit, and this was a Ninth Circuit client, is that with TPS you can adjust status. It's almost considered like an admission. So I was like, do not leave the country, do not pass go, do not collect $200. Stay here and adjust status. There's no point risking it. If you have TPS status, you have the golden ticket to adjust status. You're married to a U.S. citizen. So that's the point of continuous education, following up on all these cases. Justia.com has a news blast that comes out once a week where it lists every single case that's immigration related. There's usually between 2 to 10 cases. And most of it has to do with asylum, removal, and criminal stuff, cases where I don't handle. But I have to read each of those cases because you never know what little nugget of information that comes out on that can help your cases. And in this instance, not knowing that TPS is in California could be considered, for adjustment of status, it'll take care of the entry part. That's really bad to send a client potentially out of the country, go to Mexico on advanced parole with all the risks involved. There's additional costs to get advanced parole. There's a ticket flying back. And I've seen success in this, and people are coming back advanced parole. There hasn't been real issues, but why even take a 0.1% chance when the person could just quickly adjust status? So that's why continuing education in immigration is so vital. I think more than any other area of law, maybe other than tax. Our laws are constantly being updated between the agencies, between the courts, between the various types of courts that are various agencies and departments and executive orders. There's no excuse for not constantly staying on top of this, and it's hard. But that's why I have to spend so much time studying the law every day. I have to turn down cases because I have to keep my schedule open to spend at least 1 to 3 hours a day studying new cases, nuances of the L1, the EB1C, any books, watching videos, MCLE, doing whatever I can so I can be up to date on the laws. That's really the difference between a okay or good attorney and a great attorney. And what I'm striving for is to be that great attorney. Next is the N400. So I got a call from a client, filed the N400 himself, young guy, probably like 23. In the 5-year period they look back to, he has spent the 7-month period. This is way at the 5-year mark towards the back. He was 7 months outside the U.S. Because of that, after his interview, they issued him notice of intent to deny, saying you need to show documentation of not intending to leave the U.S. Now, the guy was about 17 at the time of the 7-month period, so I was really shocked that they had to bother about this. It was 7 months, it was not a year, and it was towards the tail end of the 5-year period, but they pushed back on it and are going to probably deny it. The guy was freaking out. If I have a case that's like this, where a person came and went, they didn't hit the 7th month mark more than 6, but they came frequently, every 6 months, come and go for the first 2 years. They had the green card, then they stayed here. Because of the nuances of how the case is going to work out, we had to file it. I can't go into too much more detail on that, but we had to file it. But when I go to interview with them as a backup, I'm taking a bunch of documentation to show, they had an apartment here, they had relatives here, they had bank accounts, they had purchased blah, blah, blah this, and they're taking this kind of exams to try to get into this kind of graduate school, all this stuff, so to prevent that from happening. Now, this guy, the young guy, 22, 23, said, I've never been arrested, I've been here for most of the life, or most of the time. Why do I need a hire attorney? Well, the reason is now you got a notice of intent to deny, and that's a big issue. If you couldn't document that you're really intending to live in the U.S. during that 7-month period, I would say, listen, don't do anything for another 7 months, stay here, and then file for naturalization. Don't waste the filing fees, and don't waste your time. And those are the kind of information, consultation information we have experience and tell people is really key. And that's why people just need, for any type of case, they need to do a full consultation with an immigration attorney to avoid wasting time and money. The most important things in life, time and money. Money because it's money, as you know, and time because that's time is taken away from being with your loved ones, doing what you want to do in life. So when I see these kind of mistakes, people call me, I say, well, what do you want me to do? I had another lady call me, and I get frustrated when they tell me this stuff and they say they didn't hire a lawyer, and I shouldn't because it's not appropriate, frankly. But it just drives me crazy. So I had one lady call me. She was from California, and she had filed for I-130, I-485, one-step adjustment for her husband. And a friend had told her, I've done these all the time. I do write them up for my friends. No problem. Just file this. It's good. So they filed it. Within 3 weeks of filing, the husband needs to go travel, so he leaves the country. Misses the biometrics. No advance parole. Nothing. It goes to hell. I-485 gets denied. All the other ones. Then she calls me and says, he went to get his tourist visa to come back in to adjust, and they denied him because they said he had intent. So what are we going to do? What are we going to do? So I said, we really messed up because you went from the easiest way you could possibly adjust status to the hardest way. Now the husband's out of the country. You're going to have to do consular processing and the mess that is, which is just horrible. And this is an Iranian family, so they have another level of hassle that they're going to have to deal with when it comes to consular processing. In addition to that, the I-130 is already approved. It was approved for the local field office. So now potentially they have to have a request where they send it from the local field office to consular processing to the NBC, blah, blah, blah. So sometimes if you could get away with asking them to just send the file, it's good, but sometimes not. And you got to file form, I can't remember what it was, I think it's I-8284. Let me see, I-824, is that it? Yeah, I-824. So they have to file I-824, pay the filing fee, which I think they increased that one as well, $465 for no reason, wait the months it takes to have the file transferred just to get to the consular processing fee. So, if she had just talked for 10 seconds to a lawyer before making this horrible decision, having the spouse leave just for small business, not thinking about the consequences, well, maybe that would have changed matters. But I see these things all the time, and it really frustrates me because it's a disservice that people just create problems for themselves just because, they can't just sit and talk with an attorney. Not everyone charges consultation fees. At least do a minimum and watch out for your own interests. So those kind of stuff get me frustrated. But overall, things are going really well. My office is just super busy. Now, super busy for me is I have such a low volume. It's different than a lot of other people. Talking to people at the ALA conference about their stuff, and people have hundreds of cases and this and that. I'm nowhere near that. But for me, I'm busy. Plus, I like to save time, as I said, to study and do these kind of videos and stuff. And as you can tell by how late I've been delivering the podcast every week now, the weekends are packed and things are just going on full blast. So, I'm too busy to take notes on the stuff I want to talk about too, which usually I just try to talk about, life and experiences and stuff on the end of this podcast. But the week's been so busy that my notes I keep in my notebook have been blank, other than 2 or 3 notes of cases I dealt with and stuff I wanted to talk about. Hopefully things will cool down necessarily, but I'll be able to better organize my time to have more fun stuff to talk about. But as it is, the biggest problem I'm facing right now is EADs, employment authorization for cases. And that's taking up a lot of my time right now because clients want the Social Security number, want everything to happen faster, get the work permit, get advanced parole, and it's just not happening. I always tell my clients from the beginning of the delays that could exist with USCIS and what kind of stuff could happen. But it is what it is. I recently got a new client that doing a K-1 visa for, and the petitioner had filed for her parents, and her parents were already living in the U.S. Were entered on a tourist visa. The father got his adjustment green card in 3 months. The mother took 1 year and 9 months. And the files were clean. That's amazing to me how a parent of a U.S. citizen I-130 adjustment combo would take 1 year and 9 months. just because when the father was especially approved that quickly. So, what do you tell your clients? Clients are going to think you're doing something wrong when these kind of issues happen. I just got an RFE this morning for a marriage adjustment case where the RFE was they didn't get the petitioner's passport or birth certificate, proof of citizenship, or the marriage certificate. Now I scan everything I sent to the USCIS. I scan any document that comes to my office and I have a date on and everything. 125% I included the passport bio page and the marriage certificate. There's absolutely no way it was not in there. But we're getting RFEs like this. So, and then the client's going to get it and think I'm an idiot for not filing the most basic documents, a marriage certificate and a passport bio page. So, but this is what we're dealing with. I guess the high volume USCIS is dealing with and all the issues and stuff they have to deal with creates problems. But luckily my clients are understanding. I let them know things are going to happen, mistakes. Normally not my fault. Sometimes it may be, but to make sure it's nothing bad. Luckily, it's rarely my fault. It's just USCIS stuff or just delays that are unnecessary, but that do happen. But that's all about client management from the very beginning. I have clients call me and they come to my office and say, this other attorney said I'll get you a green card in 2.5 months. And I said, listen, you should go to them. I should go to them. Shoot, I should give my work to them. 2.5 months, that's awesome. Now, I got 2 and 3 months, like literally 3 months exactly. But I'm never going to tell a client that, or if I do, I say, listen, don't expect that. Expect 9 months. Because if they're going to set their lives up and have vacation plans in the future, thinking they're going to get their green card in 3 months, so they set a vacation at the 4-month mark, that's so risky. Let's say they even get the interview and they go to the interview, everything's fine. Sometimes it might take too long to get the green card to the person, so they're not supposed to travel until they get the green card. So all of a sudden, they've had the interview, they're approved, but they haven't got the green card, and they got international travel in between. Well, you got to reschedule the international travel, and they don't want to hear that. So I just be really conservative. I'd be conservative with my clients and just say expect the worst, hope for the best. Naturalization, for example, last year, getting naturalized in 3 months. Now 7-8 months is the norm if we're lucky, at least in Los Angeles. And Las Vegas, it's even more and everything. So you just got to be conservative and tell the clients not what they want to hear, but what they should hear. Awful tasting medicine that there's unnecessary delays throughout this process. I have a naturalization case where huge delays for no reason, finally gets approved after the interview. It took a month for them to send the approval letter. They scheduled it. By the time we got the oath notice, it was 4 days after the oath ceremony. Go back, get a new ceremony. For some reason, they print the lawyer's name on all the paperwork instead of the client's name, the applicant's name. So then, the client's just like, what's going on? And he thinks I'd messed up. So I'm like, you don't understand how much extra time I have to put into this, try to fix this mess up, and it's still like a mess. And I went to the local office. The guy just came at me, the supervisor, with bad attitude. I had to talk to him for 2-3 minutes so he calmed down. And they realized that, first of all, I'm not going to be fighting him. I said, listen, I'm not interested in fighting. I'm just trying to fix this paperwork. And once he listened, he calmed down. But it's like, do you really have to come at me like that? I'm not an applicant. I'm a lawyer. I'm just trying to here to work with you guys. But that's the attitudes we get. And the guy was nice at the end, but he was give me super attitude at the beginning for no reason, which I wasn't having it. And that was really inappropriate. But am I going to complain to the field office? If I have to deal with it again like that and they treat me like that, then definitely I would tell the district office. But for now, that's the kind of mess we have to deal with. But just something to be mindful of in the practice, the day-to-day of the grind of being an immigration attorney. Thank you so much, everyone, for listening. This was the recap for June 26th to July 2nd. Tomorrow's going to be July 4th. I hope you all have a great time enjoying the holiday, and be safe most of all. There's going to be a lot of drunk drivers out and about. And just enjoy it. Hope you have a good barbecue. Have some good times. Until next week, bye-bye.